Hey, this is Adam Tomasi with Champion Briefs, and today I will be doing the video topic analysis for the September-October LD resolution resolved in the United States criminal justice system. Plea bargaining is just. So, before we even get into what is plea bargaining and then some effective affirmative and negative strategies, I want to emphasize that this topic is definitely, or should be definitely, interpreted as more of a philosophical resolution than a policy-oriented resolution. So the resolution does not say the United States federal government should take a certain course of action about plea bargaining. Even though, as I'll explain later, there's some possibility that the affirmative debater could propose reforms to plea bargaining as an argument that logically plea bargaining is just, and that conclusion still admits of reforms that can solve for negative argumentation, that's a reasonable and fair position to hold on the topic. Whether the affirmative can fiat those is another question, and all of that is to say that the resolution is categorical in the sense that the debate is about yes, no, plea bargaining is or isn't just, as opposed to fiating that the United States federal government should do something in relation to plea bargaining. So the affirmative debater is not committed to necessarily defend any kind of policy action. And that also opens up a bunch of interesting questions about whether the affirmative needs to achieve anything that looks like solvency, right? Because we commonly think, well, the affirmative has to do something about the impacts, that they're talking about. But the affirmative, in a way, because plea bargaining is so pervasive, there's the statistic that 95% or more cases in the criminal justice system end in plea bargaining. And more to say again on what that is in a second, but the affirmative is basically defending the status quo. So even if the resolution were a policy action, what is there for the affirmative really to fiat? They can just say plea bargaining is already a widespread practice, and I say that it is just. And again, there's that question about reforms. But this intro is just to get all the viewers thinking about how this resolution is different from other LD topics, which are more policy-oriented in how they're written. Now, in terms of what plea bargaining actually is, plea bargaining is a practice that involves criminal defendants and their attorneys negotiating with the prosecution, the state, the federal government, that has brought charges against an individual, negotiating a resolution to the case that involves not going to trial. And the basic premise of a plea deal is that the defendant admits to their guilt in exchange for lighter charges and or a lesser sentence, meaning that let's say somebody had stolen multiple cars, and under the law, the sentence that they could be potentially convicted of if they're found guilty at trial might be like 40 years. And in the plea deal, because the prosecutor wants to avoid going through a lengthy trial and all of the resources that they'd have to expend in that process. And then the defendant and their attorney are weighing the risk reward of going to trial versus just cutting right to the chase and admitting guilt, especially if the person knows that they are guilty and will very likely be found as such at trial, and they're being offered as an incentive to admit their guilt that they would get a lesser prison sentence. So that's also a good thing, from the defendant's perspective, because they're caught in a situation of choosing the lesser evil. Like, pretty high risk that they're going to go to prison regardless. Do they just skip right to the end in exchange for a lesser sentence, or do they risk going to trial? Of course, the benefit of going to trial, apart from being able to exercise your constitutional due process rights that one would say are deserved, as a person, as a citizen. That, on the other hand, you could end up not guilty. You could be found innocent of the charges brought against you. So that means 0 prison time. And that could factor into a defendant's decision making to refuse a plea deal, especially if they are willing to fight for themselves and, at trial. But there are so many systemic forces and various other pressures that contribute to defendants not taking that route. And that's something that the topic literature in the brief that we've released as champion briefs for the September-October topic dives into quite well. But also thinking about why pressures from prosecutors as well as from defense attorneys that have their own interests in wanting cases to be quickly resolved, all of that, can weigh into the decision making, even if someone might actually have a pretty good case at trial for being found not guilty. So a lot can be said on how plea bargaining is a complex institution as well as a complex decision for the defendants themselves. And also that guilt and innocence are not legally or morally straightforward in every single case, such that, and this is why I love criminal justice topics in LD, is because it's one of the easiest ways for students to understand that our systems are not fair. That, as many say, we have a criminal justice system for the rich and a criminal justice system for the poor. We have a system built on mass incarceration, rooted in structural racism, rooted in poverty, rooted in income and wealth inequality, all of it connected to racist patterns of policing, connected to excessive tough on crime policies that led to those very long sentences that then get negotiated down in the process of these plea deals. So the basis for the prosecutor's leverage, which is that they can credibly threaten very long sentences for certain crimes, like nonviolent drug offenses, let's say, that is also rooted in decades of history, decades of inequality that is compounded to create the criminal justice system that we have now. And is plea bargaining within that whole system still a just practice? That could still be true. And the affirmative will definitely want to think critically about how they can agree that, the criminal justice system is not this perfect institution, but that the alternatives are worse in general, but also that the alternatives to plea bargaining are that much worse too. So the affirmative can make this pragmatist argument about plea bargaining without believing or arguing that the criminal justice system is hunky-dory and perfect. Now, to wrap up the general introduction to what is plea bargaining, there are some nuances in terms of different types of plea bargaining that exist and different issues or benefits that arise with that. There's sentence bargaining, which simply reduces the length of time that one is in prison. There's charge bargaining, which involves negotiating down to lesser versions of the charge, where, let's say, instead of first-degree murder, admitting to second-degree murder. And that may seem inaccurate in terms of what somebody actually did and what they're confessing to, but this is all part of the, strategic decision-making that goes into the resolution of these cases. And then there are even another type of pleas, Alford pleas. Alford referring to a court case where these were, judged to be acceptable, but where a defendant can plea to the conviction, to the charges, and the lighter sentence without actually admitting their guilt. So they're able to, just like in civil court, someone can be sued. And instead of having to go to trial, they can settle out of court, just agreeing to pay some amount to the people suing them. And they can settle without admission of guilt. Like, I'm paying you, but not admitting guilt. That also exists as well within the system of plea bargaining with criminal cases. And the brief that we have at Champion Briefs also does a great job of diving into that literature as well and the pros and cons. Now, to get into the affirmative arguments first and then the negative arguments on the plea bargaining resolution. So one of the first really notable arguments on the affirmative would be a more utilitarian one, though it doesn't have to be read with the util framework, about court clog. Basically, that's a snazzy phrase for arguing that the criminal justice system would be overloaded with cases if we did not have plea bargaining. So the argument is that plea bargaining is just because the alternative is that we would have to accommodate way too many trials, and judges are already overbooked and overworked, and there are delays within the system now in terms of when people are able to get their day in court. And if we didn't have plea bargaining, that would be 1,000 times worse. And that would have consequences for delivering justice to victims of crimes. It would prevent the criminal justice system from serving multiple societal functions. So the argument here becomes that the efficiency of the criminal justice system is necessary for it to actually deliver justice and do anything that is just, and that plea bargaining is essential to that process. After all, it's the most straightforward affirmative argument, because you can say there's a reason why 95% of criminal cases, as the statistic goes, result in plea deals. It's because the alternative of no plea bargaining would be far worse. What is interesting, there are actually kind of two interrelated thoughts that I would have on this argument for the negative. The first is, on a topic such as this, where it's a categorical yes, no, is plea bargaining just, as opposed to a more policy-oriented topic, does the negative then have the right to introduce counterplans, which do fiat policy action? So the solution to court clog being just have Congress increase the budget to, hire more federal judges and give money to states to be able to do the same for their criminal justice systems. And if you have more judges, you can run more trials. Or the negative could say that I don't have to argue for an abolition to plea bargaining. In fact, the negative position can be reforms, because the affirmative has to say that plea bargaining right now is just, and the negative can say plea bargaining right now is not just, though that could change if we did a handful of steps. So that also leads to a lot of strategic case writing decisions that go into how you approach being the affirmative or the negative. And sometimes you might win debates by not just approaching the resolution straight up as this stock question of, is plea bargaining good or is it bad, right? But instead thinking about how you can use observations and procedural theory type arguments, topicality style arguments about what this resolution actually asks either or both sides to do. And you can use that to just exclude your opponent's argumentation entirely. Like, if you make a good argument for why the affirmative, for instance, gets to argue for reforms to plea bargaining, then that puts you in a really strategic spot. If you, as the negative, get to argue that reforms are actually your ground and that you don't have to argue for an abolition of plea bargaining, that means that if the affirmative has read a contention about reforms, then you as the negative could say, I'm going to concede that contention. That's actually negative offense, and then argue why the topic should lend itself to that interpretation. Now, just to wrap up the court clog argument finally, it is worth noting that there's a lot of literature on the affirmative side about how plea bargaining is necessary for the system to work. There is literature as well that you could use as affirmative ground, maybe like a negative argument as part of a more radical approach to the criminal justice system. But there is the idea that if defendants collectively decided to go to trial in a form of collective action, protest, refusing plea deals, that they could cause the system, the criminal justice system, to crash to a halt. And in doing so would force structural transformation of unjust sentencing that contributes to mass incarceration and systemic racism, and also create so many other important changes within the criminal justice system. The AF, as we have a case in the champion briefs, the AF could argue that that's why plea bargaining is just, because it's within that system of plea bargaining that defendants have the leverage to be able to refuse it and then engage in collective action. And that, creates resource scarcity within the system as a form of activism that's effective. And then the negative, however, could say that maybe that's a benefit of like abolishing plea bargaining, that it would cause the system to undermine itself, and that would be a good thing, so it would force all these transformations. So now getting into another philosophical affirmative argument, before we get into the negative argumentation. So a key argument on the affirmative is also freedom of contract. And that essentially comes down to defendants and prosecutors having the rights to bargain towards a mutually beneficial outcome, and that being an expression of the freedom of the defendant with their legal representation, and then the freedom of the prosecutor as well to pursue their interests. So it's kind of like, commercial contracts in business where you have these self-interested parties that are able to achieve these win-win outcomes. And from a libertarian perspective, from a deontological perspective, you could say that freedom of contract is good and should be valued and respected. That defendants should have the right to negotiate a lesser evil when faced with difficult, imperfect outcomes. And taking away their choice to be able to bargain would inhibit their freedom. Of course, there are two issues with this argument, one of them being the power disparities, which the negative can raise when it comes to the extraordinary leverage that prosecutors have. And there's also a lot of negative literature about the idea of vindictiveness among prosecutors, that prosecutors have these agendas where they're going to essentially throw the book at a defendant and just overload them with charges that they know they might not be able to win most of if they were to go to trial, right? So you did one crime and we're going to charge you with like 10 different interrelated things, adding up to a sentence of like 100 years, right? Just to kind of scare the defendant into agreeing to a plea deal. And where the power imbalance occurs is that a lot of people who are poor and marginalized are going to end up having public defenders as their attorneys. And public defenders are doing awesome work and they're smart people. But it is true that they're overworked and under-resourced and overburdened. And there are also pressures involved from their perspective with not fighting the hardest for every single defendant that they have. And there may also be defense attorneys that are just not great and really are willing to kind of sell their client down the river when it comes to, being ineffective, when it comes to pressuring them towards a plea deal, right? So that is another aspect of how freedom of contract may not exist with plea bargaining, and that may be a reason why the negative could argue that plea bargaining is unjust. Now, the freedom of contract argument and also the coercion and power imbalance arguments on either AF or neg are pretty strategic because they open up the ability of either debater to use a non-utilitarian framework about individual rights against their opponent, who might just be arguing about utilitarianism or about structural violence, right? That you could argue that protecting individual rights should come before either of those things, either of those more consequentialist frameworks. Now, before we get to the negative arguments, I wanted to note one other really cool and interesting utilitarian argument, which we also have in the champion briefs. And that is the argument that plea bargaining is effective at getting cooperation in organized crime cases. So when you have these large gangs and international criminal networks and so on, you have people that are on the lower levels of that operation that end up getting arrested and charged with various things, being accomplices to these larger operations of drug trafficking, human trafficking, etc. And with plea bargaining, it becomes possible to convince these like lower level like gang members to agree to cooperate with law enforcement to essentially snitch on the people that are at higher and higher up levels, like agreeing to give more information and so on in exchange for a lighter sentence. And that becomes an effective negotiating tool when it comes to taking down these transnational organized criminal groups. I think that when you're negative, you may want to make the argument that specific instances of plea bargaining do not prove that the general principle that plea bargaining is just is true. So that's one of those strategic observations. And then also making the argument that there are more effective ways to get good intelligence on organized crime than relying so much on informants, right? That's a whole fascinating discussion as well. And one of the ways that within LD you can think critically beneath the surface, like, okay, that may be one of the prevailing methods that's used to deal with organized crime, but what if, regardless of a plea deal being offered, you're not able to get any kind of cooperation? You're not able to actually, achieve that much from getting a handful of informants that might be too low level for it to be ultimately meaningful at actually apprehending those higher level leaders and so on. Now, shifting gears to the negative argumentation. So I mentioned the argument about coercion, I mentioned the argument about power imbalances. That's going to be read with a deontological, Kantian, maybe even a libertarian framework about freedom. There are also arguments to be made about mass incarceration and systemic racism. So there's great literature in the champion briefs about how plea bargaining contributes to mass incarceration, because by discouraging more defendants from fighting for themselves at trial, it means that we are overflowing the prisons and making it so that the overall machine of the criminal justice system just continues to grow and grow. And it definitely doesn't serve any kind of decarceral agenda of reducing the amount of people in prison. It increases the total quantity, even if the sentences are lighter. But then also there are studies to suggest that white defendants are more likely to be offered more favorable plea deals, and that black defendants are more likely to face all of the problematic, vindictive tendencies from prosecutors that take advantage of defendants in plea negotiations with all of the leverage that they have. So you could argue that because plea bargaining operates through racial discrimination, that it is therefore unjust. I think the affirmative against the mass incarceration argument could lean into that plea bargaining does mean shorter sentences, and that could be part of a long-term shift away from mass incarceration. Then the affirmative can argue also that the reforms part, like they could say, yeah, we need to reform sentencing, we need to reform policing, we need to change the whole system. But even if we do so, plea bargaining is still inherently just. Even if when plea bargaining is connected to all these other systemic inequalities that we might look at plea bargaining as the problem. There are a lot of affirmative articles that say, look, it's not plea bargaining that's the problem. It's all these other issues. Focus on those instead of saying that plea bargaining isn't just. Then when it comes to the argument about racial discrimination, the affirmative can also argue similarly that the same racial biases would exist and even be magnified by going to trial. And dealing with that from judges, still dealing with that from prosecutors, and that at least with plea bargaining, there may be more agency afforded to the defendant when it comes to being able to choose a lesser evil, as mentioned before, and ultimately honoring that choice. So it comes into like a really fascinating philosophical debate about how within the systems that we have now that are messed up in all these various ways, there are certain choices that marginalized people have to make or do make within those systems, which are for survival. And, plea bargaining, the process of plea bargaining might ultimately be one of those choices. I mean, does that mean that plea bargaining is just? That I'm not sure, but that is like an interesting aspect of addressing some of the other negative arguments that might come up that have to do with abolition. So there's this dichotomy of reforming the criminal justice system, which might be affirmative ground, versus abolishing the criminal justice system and replacing it with fundamentally different institutions. So that could mean abolishing prisons. It could mean all sorts of other more radical steps to be taken. There's also a word pick that could go into that, because the resolution says criminal justice system, and there are some activists who argue that we should instead say criminal legal system, because otherwise we normalize the myth of the criminal justice system, emphasis on justice, as actually delivering justice or being fair. So if we say criminal legal system, that helps us demystify the institution a little bit. One issue, though, with that word pick is the AF could say that, it's not, or it's a performative contradiction for the negative to make this deal about the whole system being flawed, and hence we have to change the words that we use. But then when you're reading a word pick, you're affirming the resolution and just tweaking a few words. So if you say, in the United States criminal legal system, plea bargaining is just, are you still really more radical than the affirmative if you still land on, plea bargaining is just, right? And the affirmative could say that that is the most important aspect of the resolution here. Now, there's another negative argument that I think it would also be really fascinating for the affirmative to engage with. So if it seems like I've given more negative arguments than affirmative arguments, I think I'm at about 4 and 4 on each. And this is kind of the fourth to wrap up, which you could actually make an affirmative argument as well. And it has to do with our constitutional rights. So the Bill of Rights making it very clear that we have a right to a trial by jury, that we have a right to an attorney, that we have a right against self-incrimination. So if you're put on the witness stand, or you are being harassed by a police officer who's trying to force you to admit that you're guilty, that you have Fifth Amendment rights against those things. You have, a Sixth Amendment right to a trial by jury. And the negative could say, one, that plea bargaining undermines our right to a trial by jury because obviously people are not going to trial. So the system's commitment to due process is significantly weakened there. And our due process rights are key to freedom. They're key to human dignity. Again, more of these non-utilitarian human rights style arguments. And then there are also some authors, as you'll see in the champion briefs, who argue that plea bargaining is essentially a form of self-incrimination, as people are conceding to their guilt. Yes, in exchange for a lighter sentence, but given the coercion arguments I mentioned above, the Fifth Amendment is supposed to protect against being pressured to self-incriminate. You could, somebody could be arrested and go to trial and just say, yeah, I did it, right? But, that's not what the Fifth Amendment's about. It's about the, pressure into incriminating oneself. Now, when it comes to the affirmative arguments, it would be very fascinating as the affirmative to make a much more abstract argument that all of our individual freedoms have to have some aspect of being waived, or that like we have to have the option to be able to do that and like forego our certain rights, where the right to vote also entails the right not to vote. The right to have an attorney also entails waiving that right and representing yourself, right? There are all these possibilities where like we have certain rights that we can voluntarily give up in specific situations. And whether we might all agree with an individual's choice to do that might not even be our place, right? Like we could say that from a justice perspective, that it should be totally up to the individual, whether they engage in plea bargaining or not. And the affirmative could say that if we didn't have plea bargaining, or if we said that plea bargaining isn't just, then what we're saying about rights is that we shouldn't be allowed to waive them, which the affirmative could say is just conceptually, philosophically, a flawed conclusion, right? So it really becomes a lot more theoretical in that sense, and then you bring it back to the resolution. The negative in response to this could argue that while some rights can be waived and should have that aspect to them, that there's also like a human dignity concern, where there's the Kantian conception of rightful honor. And a common example with that is no human being should be allowed to sell themselves into slavery, right? So something like your right to bodily integrity, right? Basic to human dignity, that should not be waivable, right? Like no one should be able to voluntarily give up their right against being tortured, for example, right? So the negative could say that the rights violations involved with the system of plea bargaining are that severe that this should not be considered when we're talking about people giving up their right to a trial, that it's not this like legal formality. It's really people are directly violating their own human dignity, and no human being should be allowed to be able to do that. And that opens up another really interesting philosophical debate about freedom itself and about choice and about rights. And this whole topic really opens up so many important questions about how we weigh different values within the criminal justice system, with efficiency versus equality, with justice as fairness and thinking about the individual, society, reform versus abolition, and so many other insights that you'll find volumes of within the champion briefs that we've released for the September-October topic. So that's the conclusion of my topic analysis. And thank you all for watching. And make sure to check out our brief, because it has hundreds of cards for all of the arguments that I've mentioned here. Thank you so much.